Good evening, everyone. My name is Kathleen Campbell, and I want to welcome you to the third in a series of webinars presented by the Coalition to Stop CO2 Pipelines. We are offering these webinars in response to a proposal by Navigator CO2 Ventures to construct a 1,300-mile-long high-pressure carbon dioxide pipeline, collecting carbon dioxide from industries across 5 states and injecting it underground in central Illinois. Our goal is to fully inform residents, landowners, and counties in the affected areas and prepare them to come together and oppose the pipeline. I am a resident of Glenarm in Sangamon County. The proposed pipeline would pass close to my house and those of my neighbors, so close, in fact, that a rupture may not be survivable. This pipeline threatens our health, safety, and property values for both homes and farmland. This is why I'm here tonight and why I encourage you to join the effort to stop the Navigator pipeline. Tonight, we will hear from Joseph Murphy, an attorney with Meyer Capel in Champaign, Illinois. Mr. Murphy will explain how you can exercise your right to intervene as Navigator seeks approval of their project before the Illinois Commerce Commission. He will describe how the ICC process works and how you can unite with your neighbors to stand up for your rights by intervening in that process. Now, during the presentation, we encourage you to enter your questions by going to the bottom of your screen and clicking on the Q&A button. At the end of the presentation, we will call on you to ask your question of Mr. Murphy. And now I'd like to turn this over to Kathy Hamill, a member of SOIL, Save Our Illinois Land, and also a part of the Coalition to Stop CO2 Pipelines. Kathy will introduce this evening's speaker.
Thank you. It's my pleasure this evening to introduce Attorney Joe Murphy. Mr. Murphy currently is the president of Meyer Capel law firm, which has its offices both in Champaign and in Bloomington, and he has an impressive professional background. Mr. Murphy graduated in the top 5% of his law school class from the American University in Washington, D.C. Following law school and a clerkship with a federal district court judge, Mr. Murphy began his practice with a Wall Street law firm, where he specialized in cases that involved trademark licensing and intellectual property. He later moved to a Washington, D.C.-based firm where he expanded his expertise to include franchise litigation and counseling. Since coming to Champaign in 1994 to join Meyer Capel, Mr. Murphy has focused his practice on a combination of intellectual property and telecommunications law, the latter of which involves unraveling the many rules and regulations that apply to utilities. Joe has represented several clients before the Illinois Commerce Commission, as well as on appeal taken from ICC rulings, including a case that went up to the Illinois Supreme Court and resulted in significant relief for his client. Joe knows how the ICC works. He has frequently succeeded in obtaining the rulings needed to protect his client's interests. No attorney practicing today can say that they have direct experience with cases involving the application of Illinois law to CO2 pipelines. And this is because, until now, no matters related to CO2 pipelines have been litigated in our state. Our concerns regarding Navigator's plans are on the cutting edge of the law in our state. Mr. Murphy's years of experience representing regulated businesses and his many appearances before the ICC well qualify him to confront Navigator and to see that justice is done for Illinois landowners. Thank you so much, Joe, for agreeing to address us this evening. We're all eager to hear what you have to tell us about how we can make our concerns known to the ICC.
Thank you, Kathy, and thank you all for having me. One of the things I want to make clear at the outset, while it is my hope and expectation that I will represent some part of this group or some group that comes out of this before the Commerce Commission and represent them diligently and really advocate a position. My goal here this evening is not to give anybody legal advice. My goal here this evening is to explain the Commerce Commission process, and so that you who are listening will understand what it would mean for you to intervene either individually or presumably as part of a group. So I want to talk a little bit about the process and a little bit about the dynamics. So, so you understand, the Commerce Commission itself is made up of 5 members. Those members, I believe 3 of them are intentionally they're Democrats because we have a Democratic governor, but there are also 2 Republicans. The Commerce Commissioners themselves are not the ones who decide the facts in these cases, or at least they're not the ones who hear the facts. The case is funneled through an administrative law judge. And that process of getting from the administrative law judge to the Commerce Commissioners themselves is a complicated element that comes into this process, and it will become more evident later because it has a strong impact on the schedule. But when Navigator or any company brings a petition in front of the Commerce Commission, they are required to notify the adjoining landowners and the municipalities, including the counties and the cities and villages that it will impact. But we'll become aware of it, and this group is watching, so we'll become very, very particularly aware of it. As soon as they file a petition, they may file with the petition simply a statement of what they're trying to accomplish. They may also, or alternatively, file it along with evidence, and that evidence is usually in the form of written testimony that, if any of you have ever seen a deposition transcript, it sort of looks like that because it's a written document where there's a questioner, so you have Q and A, and the witness is the answer part of that. But you can literally read as a narrative what their position is and what they say their evidence is. They can attach all sorts of documentation to that. And the important part of whether they put their evidence in at the very beginning is, as soon as they file their petition, the Commerce Commission, through an administrative law judge, will set, probably within 30 days, maybe sooner, maybe a little later, but probably a little sooner, a hearing to set a schedule. The hearing to set the schedule is going to depend in part on how much of the evidence the company, the petitioner, has put in to begin with. Because if the company does not put the testimony in at the very outset, the first date that will be set is a date for the company to put in their actual testimony. The important part of intervening is that once a party has been admitted, has been allowed to intervene in this, that party has, in essence or in theory, as much say as the company does about what schedule is set. So it is valuable to intervene very early, to intervene before that scheduling conference, because as things happen, for example, once the scheduling conference happens, people who intervene after that conference are essentially required to accept that schedule. So if you want to be part of setting the schedule, you want to intervene early. In order to intervene, you have to demonstrate that you have a concrete interest in the outcome of the docket. So the most obvious concrete interests are the people who are landowners, either contiguous to the route or nearby the route. Also, the counties through which it travels, the municipalities by which it travels, will all have pretty much an automatic right to intervene. And most government entities are going to be given a lot of latitude as to what their interest is to intervene. So as I understand it, there are people on this call who really are along the route. There are other people who are interested in this for other reasons. Some of them are more general than others. But if you put together a group that has the immediate interveners, the immediate landowners, it is likely, it's very probable that the commission will allow the group to intervene and the group to act as a group as they move forward with this. And while everybody has a right to intervene on his or her own behalf, you're going to get more bang for your buck normally by being part of a larger group that shows that they have, made it the time and investment and effort to do this. You're just going to be heard a little louder. So there is a benefit to be with a group. But again, anybody who has an interest can intervene separately and be heard separately. So once you get to the scheduling hearing, and we'll just say that it's a month after the petition is filed, one of the things we have to note about the statute we're working under is it explains that the commission has 11 months to make a decision. And the legislature does this in some instances and not others, solely so that these cases do not go on and on and on. I would note that in this statute, there's no real remedy if the commission goes beyond 11 months. No one's allowed to go to court over that. In fact, it says their failure to make a decision in 11 months, is not a decision for or against the petition or the route or anything else. It's kind of a nullity. Nevertheless, the commission is going to be focused on their obligation to decide this in 11 months. So when we set a schedule, we're going to want to schedule that where we see the testimony that the petitioner, the navigator, puts on. And then there's a period where we have a right to do what's referred to as discovery. We have a right to ask questions that they would give narrative answers to. We can seek the documents they're relying on, and we can build in and will insist on building into the schedule time both for us to formulate the questions, because we'll need to see the testimony. I presume we'll have some one or more expert witnesses. We'll need them to see and evaluate the testimony. And we'll need their eyes on it to say, what questions does this raise? What holes have they left? What ambiguities have they established, so that we have time to ask the questions, and then they'll need, they're presumptively entitled to 28 days to respond. They might commit to respond sooner. They might have to say it will take longer, but that's really on them. And we're entitled to both ask the questions and get the responses. And in fact, we can, in instances, ask for 2 rounds of questions, because if the answers they give us are themselves ambiguous, we have the ability, the right to go and pursue the final, or at least the informative answers to the questions we're asking. After that, we will be entitled, as will all interveners, probably on the same schedule, to file our opposing testimony. And bear in mind that we could have interveners of many different stripes, and it is possible that there will be interveners with whom we disagree. And if that happens, the schedule has to take into account that different interveners could possibly have to respond to each other. And for the same reason that we're allowed to ask the petitioner questions, once we file testimony, they can ask us those questions. So there's a period of discovery there too. So if you're counting on your calendar, you're probably looking at now at least 3 months, maybe 4 months of this kind of pre-hearing discovery. And you say, well, we have 11 months. What's the problem here? I'm going to talk about the end of the process a little bit, just to show you how the calendar works. When all the testimony is prepared for admission, the administrative law judge will set a hearing date. At the hearing, the paper testimony that I described will be for the most part, admitted into testimony, and then different parties will be allowed to question witnesses. So if Navigator puts in 3 witnesses, their testimony will be admitted, and then the witness will be made available for live cross-examination. So that's true of any witness who's puts in testimony from any side. Their testimony will be put up, presumably admitted, and then the witness will be available for a live cross-examination. And I explain that process because that hearing can take a day, it can take a week. It really depends on the nature of the hearing, what all is contested, what all can be presented by our own witnesses, and what we need to get from cross-examination, and also the time Navigator takes to cross-examine us. And again, if interveners have different interests, there's cross, so to speak. But once the ALJ hears all that testimony, he or she will mark the record heard and taken, meaning the evidence is in, and I'll say she has to write a proposed decision. It will take a finite amount of time for her to write a proposed decision, and that could be 2 weeks, a month, 2 months. I expect this to be a very complicated case, and I expect the ALJ this will be as novel to her as it is to some of us here. So that's going to take some time. Well, once the ALJ issues her proposed decision, the parties will have a chance to take exception. And depending on which direction she goes on whatever issues, it could be primarily the petitioner taking exception to her denial of something, or us taking exception to her grant of something. But that process creates a briefing schedule. So normally, once the ALJ puts out her decision, there are 2 to 3 weeks for anybody who wants to take exception to file exceptions, and then another 2 weeks for anybody who wants to reply to the other side's exceptions. Only at that point does the ALJ read those. She may adjust her decision, she may not. She'll submit it to the commissioners, and that is literally the first time the commissioners are going to take a look at this. So they will see the ALJ's explanation of it. She'll refer to all the testimony, so she's not going to just ignore half of it. She will refer to all the testimony. She will propose a decision structure, and this will look like a commission order. She'll give it to the commissioners, and normally they act on it without really discussing it at their open meetings. They just say, the ALJ has given us this proposed decision. Are we okay with it? Vote yes, vote no. Occasionally there will be discussion at the commission meetings where they will say, one of them will say, I don't like what she did in section 7. And you may or may not have any idea what they're talking about. So sometimes they'll send it back to the ALJ for revisions. But all of that is to say that their 11-month calendar, the last really 3 to 4 months of it, is taken up after the ALJ makes her decision. So she's got to get to a hearing within 11 minus 4, don't make me do math, 7 months. And all of these schedules have all the problems of everybody else's real life schedule of summer vacations and Christmas breaks and Thanksgiving holidays. So it's a bit of a chase to make sure that you get all these things done. But the overall goal of the process is for the petitioner to be able to put their case on, for anybody who questions it to be able to ask detailed questions of the petitioner about their basis, and then to present their own witnesses who will either provide completely different opinions or analysis of the shortcomings of the petitioner. And in fact, the petitioner can then, in some instances, and they can put in reply testimony, because as the petitioner, they're presumptively entitled to speak first and speak last. All of that has an impact on the schedule. And, as we pull together, because Navigator has as long as they want in order to start this process. To a major extent, we are limited in what we can accomplish until we see what they file. So when we try to set the schedule, Navigator, and they're not unusual here, and I haven't met them, but they're going to come in and say, hurry up, hurry up, hurry up, hurry up. And as the respondents, we're going to say, we need some time, we need some time, we need some time. And by the way, the commission staff also has a role here. So the commission has a professional staff. They are not commissioners. They're not ALJs. They are professionals who presumably have some, they have engineers, they have economists, they have accountants, they have policy people. I'm not deeply familiar with their pipeline people, but the commission staff will also take a position. They can take a position with us. They can take a position against us. They can take an entirely different position. They may ask for a different set of testimony dates, because they may say, they do this in some instances, we want to see the petitioner's testimony, we want to see the intervener's testimony, and then we want to be able to comment on all of it. So again, that is something that spreads the calendar out. And what you find is 11 months is a very short time to really air a complete explanation of this complicated process and get everybody's positions on the record. And again, I'll circle around to that is why it is beneficial for groups of people with similar interests to group together and present their testimony, both because there are clearly cost savings if you all get the same attorney and if you all get the same experts, but there's also some heft in having one expert who represents 50 parties rather than 25 experts who represent 50 parties. So this is all a goal of getting everybody's voice heard as well and as clearly as the commission and the ALJ have time to do. And I don't take that lightly. I mean, it's our role, and certainly the role of an attorney, to try to capsulize this so that it is something that the ALJ can understand what this group is trying to accomplish and what our basis is for saying any of that. So that is the overall process. Just looking ahead, the commission will eventually make a decision. They'll probably make it within the 11-month time frame. If the commission makes a decision that we find objectionable, we have there is a procedure for appealing that. That procedure requires first that we go back to the commission and point out to them what we think are the errors of their ways. And then if they don't change it to our liking, we can go file in the appellate court. So this is really, we can pick an appellate court, but presumably we'll pick the appellate court that probably includes Christian County, since I understand that's where where this stuff is all being shipped to. But it can really be any appellate court. And there is an appeal. The appellate court has to hear any appeal we bring. The Illinois Supreme Court has a discretionary appeal, so they can take an appeal or not take an appeal. So one of the observations, and again, I don't want to dig into a deep legal analysis of it, but any of you who have read the statute that's involved here, the statute opens up by suggesting that these kinds of CO2 pipelines are in the public interest. That's a legislative finding. So there is, I don't want to kid anybody, this is a bit of an uphill pull to try to figure out how to go at this and how to go at these things. There are also some parameters around, or at least the statute tries to set some parameters about what parties can raise what issues. So, for example, the statute seems to suggest that only governmental entities can talk about public safety. But it also says that property owners can talk about how the proposed pipeline or facility will affect property values in general, not my farm or your farm, but how it impacts the community. My expectation is if we present testimony, or if we try to present testimony about the negative impact on public health, we may draw an objection from the petitioner about whether that's our space, but I would certainly argue to anybody that having public health issues has a direct impact on the property values of all the land in the area. So there are some, there are some difficulties in the statute. The main difficulty is that the legislature passed it in the first place. And I assume that there are people here who, part of their life's effort is to get the legislature turned around. But right now we deal with the statute we have. So that is the overall process. I would be happy to take general questions or direct questions about any of those elements.
Well, this has been a super informational piece, Joe, and I thank you for that. I think before we go into Q&A, we want to make sure we have the opportunity before we lose people to talk about organizing and next steps there. So Rick, why don't you take a few moments on that, and then we'll move to the Q&A. So put your questions in the Q&A blocks, and we'll get to those el pronto, really quick.
Okay, good evening, everybody. I'm Rick Stuckey with Save Illinois Land and the Coalition to Stop CO2 Pipelines. And I'm just coming off almost the end of a 3-year battle in the Illinois Commerce Commission. So I'm recognize all the steps that Joe has just gone through with us. I might just add one thing to that. The commission also has a website, and it has a facility for you to post your comments in the website. It is a total and utter waste of time in terms of getting it to the commission. It is value to the press to hear there are 1,000 objections and so on, but the commission will never look at those comments in their website. It's just a facade that they think they're listening to the public, but they're not. So don't think this is the only way that you'll get a word through to the commission. You can do all sorts of other things on the outside, but going through this intervention route is the absolute only way of doing it. I'm just here to say now that we would like to hear from you in the chat if you're interested in getting involved with this in this process going forward. What's going to happen is we're going to form another organization specifically to handle the intervention, and it'll have a board of directors so that Joe can bounce ideas off a few people and get answers that are sort of authoritative that will affect everybody. It'll also deal with the money side of this, and it'll be Joe's client, and it will take care of the fees and things like that. So we'll talk more about the actual mechanics of getting this together, but we'd like to know from you just now if you're interested in participating in any way in this process and being involved in it and getting your views heard by the commission. So if you would be interested in doing that, please put your name in the chat and just say, I'm interested, and we'll get back in touch with you after that. With that, I can pass it back to Pam.
So this is great. So I think it looks like we've got our answers here. So I thank you for that. And I'm going to throw a slide up here that again helps with our, I'll make sure I save this, don't notice this, okay. That I actually make sure that that we give you our information as we move forward, and we will see you next time. So thank you.
Thank you very much.